So what is this dispute about?
Well, Roz, I think most Australians are familiar with the UGG boots, the iconic soft lambskin boots. They've been around since the 1960s when they became very popular with Australian surfers. And here in Australia, UGG boots are a generic term for a style of shoe, and there are many manufacturers of UGG boots, including Eddie Oiger's outfit, which has a small factory in Western Sydney. But Roz, overseas, the situation's diametrically different. Back in the early 1980s, an Australian businessman named Brian Smith went to the USA and he managed to register a trademark over the word UGG. And that US trademark was then sold years later to a giant retail company called Deckers. And they went on to register the UGG trademark in another 130 countries all around the world. So in this period, Deckers has invested many millions in promoting their UGG brand all around the world. And now, as they see it, they are actively protecting their intellectual property by taking action against Eddie Oiger in Western Sydney.
So how did Eddie Oiger infringe the trademark of US retailer Deckers?
Well, Eddie Oiger sells to the Australian market, but over a number of years, he did sell via his online website 13 pairs of UGG boots to US-based customers. Unfortunately, 4 of those turned out to be investigators employed by Deckers. So Deckers commenced court proceedings in the US court claiming that Eddie Oiger had willfully infringed their company's trademark in the USA. They don't have a trademark here, but they do have one there. And in 2019, there was a trial in Chicago, and at that trial, the court ruled in favour of Deckers and against Eddie Oiger.
So what was the argument run by Eddie Oiger, ultimately unsuccessful?
Well, Roz, there were 2 really, really interesting arguments. One that argues, well, should be a generic term in the USA, and the other one was that it is a generic term here in Australia. So in terms of the US argument, Eddie's lawyers had witnesses give evidence that back in the 1970s, UGG boots were very popular with Australian surfers who then took them back to America, or took them to America, as well as American surfers returning to the USA. And everybody in the surfer community understood that UGG was a generic, in California and elsewhere, understood that UGG was a generic term for a style of shoe. It wasn't a brand name. And there were lots and lots of different people selling these UGG boots in the USA, imported from Australia. But that argument was rejected by the court in Chicago in 2019 because the court said, look, the test isn't what a niche community like the surfer community thinks. Rather, it's what the wider American population or the wider American consumer market thinks. And they weren't familiar with this term. So it was okay for this term to get trademarked. In terms of the Australian situation, there's a general argument in trademark law that you shouldn't allow registration of a term that is an obvious generic term in another country. And this argument is known as the doctrine of foreign equivalence. But this argument fails because it was held that the doctrine of foreign equivalence only works for non-English words, right? So it meant that in American courts, the Serbian word for coffee, you couldn't get a trademark for that in the USA. But we speak English here in Australia, so the Australian word for lambskin boot, UGG, you could get a trademark. So that's how they managed to win in the court. And unfortunately, last week, the US Supreme Court said, no, that decision's fine. We're not letting you come to this court to seek an appeal.
The devil is in the detail always, isn't it, Damien? Thank you. More on the Law Report and RN at 5:30.
Terrific.